The other two principles are Lopez, and this case really is not, Lopez is a limit on the affirmative exercise of people who are already in commerce. The question is there any other limit to people who aren't in commerce? And so I think this is the case that really asks that question. And then the first point, which was, I take it to be the Solicitor General's point, is with all due respect, simply a description of the insurance market. It's not a limiting principle, because the justification for why this is a valid regulation of commerce is in no way limited to this market. It simply says these are economic decisions. They have effect on other people. My failure to purchase in this market has a direct effect on others who are already in the market. That's true of virtually every other market under the sun.
And now maybe return to Justice Sotomayor's question.
I'd be delighted to, which is, you're absolutely right. Once you're in the commerce power, this Court's not going to police that subject maybe to the Lopez limit. And that's exactly why I think it's very important for this Court to think seriously about taking an unprecedented step of saying that the commerce power not only includes the power to regulate, prescribe the rule by which commerce is governed, the rule of Gibbons against Ogden, but to go further and say it's not just prescribing the rule for commerce that exists, but it is the power to compel people to enter into commerce in the first place. I'd like to say two very brief things about the taxing power, if I could. There are lots of reasons why this isn't a tax. It wasn't denominated a tax. It's not structured as a tax. If it's any tax at all, though, it is a direct tax. Article 1, Section 9, Clause 4, the framers would have had no doubt that a tax on not having something is not an excise tax but a forbidden direct tax. That's one more reason why this is not proper legislation, because it violates that. The second thing is I would urge you to read the license tax case, which the Solicitor General says is his best case for why you ignore the fact that a tax is denominated into something other. Because that's a case where the argument was that because the federal government had passed a license, not a tax, that somehow that allowed people to take actions that would have been unlawful under state law, that this was some special federal license to do something that was forbidden by state law. This Court looked beyond the label in order to preserve federalism there. What the Solicitor General and the government ask you to do here is exactly the opposite, which is to look past labels in order to upend our basic federalist system. And
Would you tell me, do you think the states could pass this mandate?
I represent 26 states. I do think the states could pass this mandate. But
is there any other area of commerce, business, where we have held that there isn't concurrent power between the state and the federal government to protect the welfare of commerce?
Well, Justice Sotomayor, I have to resist your premise, because I didn't answer yes, the states can do it because it would be a valid regulation of intrastate commerce. I said yes, the states can do it because they have a police power. And that is the fundamental difference between the states on the one hand and the limited and enumerated federal government on the other.
Thank you, Mr. Clement. Mr. Carbon?
Thank you, Mr. Chief Justice. May it please the Court, I'd like to begin with the Solicitor General's main premise, which is that they can compel the purchase of health insurance in order to promote commerce in the health market because it will reduce uncompensated care. If you accept that argument, you have to fundamentally alter the text of the Constitution and give Congress plenary power. It simply doesn't matter whether or not this regulation will promote health care commerce by reducing uncompensated care. All that matters is whether the activity actually being regulated by the Act negatively affects commerce or negatively affects commerce regulation so that it's within the commerce power. If you agree with us that this exceeds commerce power, the law doesn't somehow become redeemed because it has beneficial policy effects in the health care market. In other words, Congress does not have the power to promote commerce. Congress has the power to regulate commerce. And if the power exceeds their permissible regulatory authority, then the law is invalid.
Well, surely regulation includes the power to promote. So since the New Deal, we've said there's regulation in there's a market in agricultural products. Congress has the power to subsidize, to limit production, all sorts of things.
Absolutely, Chief Justice, and that's the distinction I'm trying to draw. When they're acting within their enumerated power, then obviously they're promoting commerce. But the Solicitor General wants to turn it into a different power. He wants to say we have the power to promote commerce, to regulate anything to promote commerce. And if they have the power to promote commerce, then they have the power to regulate everything, right?
I don't think you're addressing their main point, which is that they're not creating commerce in health care. It's already there, and we're all going to need some kind of health care, most of us will, at some point.
I'd like to address that in two ways, if I could, Mr. Chief Justice. In the first place, they keep playing mix and match with the statistics. They say 95% of us are in the health care market, okay? But that's not the relevant statistic, even as the government frames the issue. No one in Congress or the Solicitor General is arguing that going to the doctor and fully paying him creates a problem. The problem is uncompensated care. And they say the uncompensated care arises if you have some kind of catastrophe, hit by a bus, have some prolonged illness. Well, what is the percentage of the uninsured that have those sorts of catastrophes? We know it's got to be a relatively small fraction. So in other words,
but we don't know who they are.
We don't. No, and we don't know in advance, but that doesn't change the basic principle that you are nonetheless forcing people for paternalistic reasons to go into the insurance market to insure against risk that they have made the voluntary decision that they have decided not to.
But the problem is that they are making the rest of us pay for it, because as much as they say, well, we're not in the market, we don't know when the time when they will be, and the figures that how much more families are paying for insurance because people get sick, they may have intended to self-insure, they haven't been able to meet the bills for cancer, and the rest of us end up paying because people are getting cost-free health care. And the only way to prevent that is to have them pay sooner rather than later, pay up front.
Yeah, but my point is this, that, with respect, Justice Ginsburg, conflicts the people who do result in uncompensated care, the free riders. Those are people who default on their health care payments. That is an entirely different group of people, an entirely different activity than being uninsured. So the question is whether or not you can regulate activity because it has a statistical connection to an activity that harms commerce. And my basic point to you is this. The Constitution only gives Congress the power to regulate things that negatively affect commerce or commerce regulation. It doesn't give them the power to regulate things that are statistically connected to things that negatively affect commerce because... I'm sorry.
Please.
I was just going to say, because if they have that power, then they obviously have the power to regulate everything, because everything in the aggregate is statistically connected to something that negatively affects commerce, and every compelled purchase promotes commerce.
So in your view right there, I'm just picking on something I'd like to just, if it turned out there was some terrible epidemic sweeping the United States, and we couldn't say that more than 40 or 50%, I can make the number as high as I want, but you'd say the federal government doesn't have the power to get people inoculated, to require them to be inoculated, because that's just statistical.
Well, in all candor, I think Morrison must have decided that issue, right? Because people who commit violence...
Is your answer to that yes or no?
Oh, I'm sorry. My answer is no, they couldn't do it because...
they could not do it. They cannot require people, even if this disease is sweeping the country, to be inoculated. The federal government has no power, and if there's terror... okay, fine. Go ahead. Please turn to Justice Kagan.
May I just please explain why?
Yeah.
Violence against women obviously creates the same negative impression on fellow citizens as this communicable disease. And it has huge effects on the health care of our country. Congress found that it increased health care costs by...
I agree with you that it had big effects, but the majority thought that was a local matter.
I
think that's his point.
I don't know why having the disease is any more local than beating up a woman, but my basic point is that, notwithstanding its very profound effect on the healthcare market, this Court said the activity being regulated, i.e. violence against women, is outside the Commerce Clause power. So regardless of whether it has beneficial downstream effects, we must say no. Congress doesn't have that power. Why not? Because everything has downstream effects on commerce, and every compelled purchase promotes commerce. It by definition, helps the sellers and existing customers.
Mr. Carbon, isn't there this difference between Justice Breyer's hypothetical and the law that we have before us here? In his hypothetical, the harm to other people from the communicable disease is the result of the disease. It is not the result of something that the government has done. Whereas here, the reason why there's cost shifting is because the government has mandated that. It has required hospitals to provide emergency treatment, and instead of paying for that through a tax, which would be borne by everybody, it has it has set up a system in which the cost is surreptitiously shifted to people who have health insurance and who pay their bills when they go to the hospital.
Justice Alito, that is exactly the government's argument. It's an extraordinarily illogical argument.
Fine, then, if that's so, is it let me just change my example under pressure and say that, in fact, it turns out that 90% of all automobiles driving interstate without certain equipment put up pollution which travels interstate, not 100%. Maybe only 60%. Does the EPA have the power then to say you've got to have an anti-pollution device? It's statistical.
What they can't do, yes, if you have a car, they can require you to have an
Then you're not going on statistics. You're going on something else, which is what I'd like to know what it is.
It's this. They can't require you to buy a car with an anti-pollution device. Once you've entered the market and made a decision, they can regulate the terms and conditions of the car that you do, and they can do it for all sorts of reasons. What they can't do is compel you to enter the market.
Now and then you've changed the ground of argument, which I accept as totally legitimate. And then the question is, when you are born and you don't have insurance and you will, in fact, get sick, and you will, in fact, impose costs. Have you, perhaps involuntarily, perhaps simply because you are a human being, entered this particular market, which is a market for health care?
If being born is entering the market, then I can't think of a more plenary power Congress can have, because that literally means they can regulate every human activity from cradle to grave. I thought that's what distinguished the plenary police power from the very limited commerce power. I don't disagree that giving the Congress plenary power to mandate property transfers from A to B would be a very efficient way of helping B and of accomplishing Congress's objective.
I see the point. You go back to Justice Kagan. Don't forget her question.
I've forgotten my question.
I was facing the same dilemma, Justice Kagan.
Well, let me ask the question that I asked Mr. Clement. It just seems...
It's what it means to be the junior justice.
It just seems very strange to me that there's no question we can have a Social Security system besides all the people who say, I'm being forced to pay for something I don't want. And this, which seems to me, to try to get care for the ones who need it by having everyone in the pool, but is also trying to preserve a role for the private sector, for the private insurers. There's something very odd about that, the government can take over the whole thing and we all say, oh, yeah, that's fine. But if the government wants to preserve private insurers, can't do that.
Well, I don't think the test of a law's constitutionality is whether it more adheres to the libertarian principles of the Cato Institute or the statist principles of someone else. I think the test of a law's constitutionality is not those policy questions. It's whether or not the law is regulating things that negatively affect commerce or don't. And since obviously the failure to purchase an item doesn't create the kind of effects on supply and demand that the market participants in Wickard and Raich did, and doesn't in any way interfere with regulation of the insurance companies, I don't think it can pass the basic...
I thought that Wickard was, you must buy. We're not going to let you use the homegrown wheat. You have to go out in the market and buy that wheat that you don't want.
Oh, but let's be careful about what they were regulating, Wicker, Justice Ginsburg. What they were regulating was the supply of wheat.